So there have been various reactions following the signing of the Expropriation Bill into law by President Cyril Ramaphosa this past week, having been tabled and ultimately passed by Parliament on the 27th of March 2024. So we're going to be sifting through the facts and figures in relation to this, perhaps also try to gain a clearer understanding of its implications and who it ultimately benefits and whether it is an effective tool for transformation. Adv Tembeka Ngcukaitobi, lawyer and best-selling author of Land Matters and The Land is Ours, weighs in for more. Advocate Ngcukaitobi, good morning. Thanks for making time with us on this hour.
Thank you for the invitation and good morning.
Let's jump straight into it. So, I mean, you've written that the idea of expropriation without compensation is not novel in our law. So perhaps on the back of that, we could get your reaction following the president signing in of the expropriation bill at large.
Yes, I think that there is a distinction that South Africans ought to draw between symbolism and substance. Much of the response that I've watched in the last 2 days has been to the symbolism. What does expropriation without compensation mean for the markets? What does it mean for the politics? What does it mean about commitment to property rights and commitment to transformative constitutionalism? Much of that debate is a symbolic debate. But there is the question of what substantively the bill or the act actually means. And even that needs to be distinguished between what it means for property rights holders and what it means for the marginalized and the vulnerable. So for those who have no land because land was taken away by force, by trickery and theft under colonialism and violence and apartheid. The bill is symbolic only at an aspirational level. It will not, in fact, transfer land from landowners to dispossessed and marginalized people. And for property rights holders, what I think they have been responding to is that it means that the South African government no longer respects private property rights. That too is wrong. The South African government is very committed to private property as a concept. Wrongly in our argument, certainly in my argument, wrongly, but it's very committed to the idea of private property. In fact, it worships private property. And the nature of the bill, there are two particular problems with it. The one is that it's a highly procedural bill. And some of the procedures are internally inconsistent. And so it makes it extremely difficult for the state to actually acquire property. The second is that its scope, substantive scope, is actually a very limited scope. The purpose of this bill under Section 2 and 3 is to enable the state to acquire property for its own uses. In other words, for the fulfillment of the mandate of the Department of Public Works. This is not the bill to transform property relations in the country. It's not the bill to transform land relations in the country. So I see the real critique of the bill being, because it's a highly procedural bill with vague and contradictory procedures, it will be ineffective. And also because it's a substantively limited bill, it will not be as disruptive to the property markets as the sort of a lot of misleading reportage has been on this bill.
All right, thank you for painting that picture and for outlining that for us. When we look at concepts of just and equitable, it's difficult to apply. So if we're looking at the methodology that is required, I mean, talk to us what comes to the fore on that front, the methods that are needed, if the courts are going to then be the final arbitrators for this.
Yes, I think that, yes. Perhaps let's just break down how this bill envisages the process of expropriation. So there are two steps, I mean, two broad steps. There are many steps, there are about 18, but there's just two broad steps. The one is the expropriation itself, the act of taking property from private owner to the state. There are many ways of acquiring property, right? You can go to an open market. This afternoon on Sunday in Johannesburg, many estate agents would be showing off houses. So that's called an open market. Or you can go to an auction, when someone is unable to pay and then the property is taken by a bank and then it's put on an auction. Or you can get a donation, somebody is dead and they acquire an inheritance. Or, as we know in South Africa, you can just acquire it by force. That's what happened under the Group Areas Act. The bulldozers came and they took. So there are many ways of acquiring property. Expropriation is one of them. And it is internationally recognized. And it is also historically entrenched in South Africa. During the days of the Union government, the government could acquire property from anyone, and it had no obligation to pay any compensation. And there are many judgments from 1910, 1911, 1912, 1913, after the passage of the Native Land Act, which make it clear that the state is under no obligation to compensate an owner in circumstances where it requires the property for its own purposes. So many railway lines, many schools, many hospitals, many public facilities were built on the back of expropriation. So it's internationally recognized, historically recognized. And the 1975 Act that we were dealing with itself was an instrument to enable the apartheid government to acquire property in order to create the Bantustans. It's part and parcel of that larger political project. So expropriation is a tool to enable the state to acquire property for its own usages, because it's recognized that the state cannot always seek the consent of the individual, because the public interest sometimes should override private interests. So that's category one. It's a tool for acquisition of property. And so what the bill then does is to unpack the steps that the government needs to undertake in order to acquire that property. And those tools are all embedded in administrative justice. So you give notice, you consult, you advertise, you negotiate, you mediate, and maybe sometimes you even arbitrate or you go to court. But it's a design based on administrative justice. And then there's step two, which is a highly contentious one.
Yep.
And that is deciding the price for the property. Now, as I say, in the past, it was the case in this country that Black people lost land rights without any compensation. We know this under the Group Areas Act. We know it even under the laws that were applicable prior to the institution of apartheid. Right? That land could just be taken by the state without compensation.
Yeah.
So what the government has done in this case is that it has not decided on a one-size-fits-all. So not all land or property that is taken will be without compensation. What it has done is that it has designed a scale that moves from full market value to nil compensation. And that's complicated about how you decide market value to nil compensation. But we always needed to have a bill that would empower the state in appropriate instances. In fact, I made the argument as early as 2018 that a one-size-fits-all approach to compensation is wrong. What we need is a case-by-case approach to compensation. So there are instances where the state must pay full compensation and sometimes above market value compensation, depending on the extent of the disruption and the impact of the expropriation. And then there are other instances, and some of the indicators are tabulated in the Act: stolen property, land that has been acquired but has been abandoned, land that has been acquired illegally, etc., where with a nil compensation would be justified. But here's the trick. The state has no power to decide whether it should be market-based compensation or it should be nil compensation. It can only propose. It is only the judges that have the power to decide.
All right. Thank you for that, because The aspect of no compensation has also been much of discussion, just what it implies on that front. But obviously there are precise calculations and strict procedures on that front, even checks and balances. But I wonder also 30 years into our own democracy, looking at the issues that we're grappling with, perhaps you could talk to some of the other concerns that come to the fore. State capacity to execute, concerns about corruption as well, the rate of the compensation rate that is paid. These are deficiencies. Ultimately, how effective are we in overcoming them from your vantage point where we stand?
Yes. Yes, in order to implement this is a complicated law. Let's not underestimate the enormity of enforcing expropriation, let alone determining compensation. It's a complicated piece of legislation because it's designed to make it difficult for the government to forcibly take property. It's clear that that's the design of the sponsors of this legislation. So therefore that means is that we've got to have a capable bureaucracy, capable state bureaucracy that will give effect to it. And capability means it's got to be interested in what it is doing. It's got to have the political will to force a transfer through, even if there's resistance. The second is that it's got to have the nose, the technical ability, right, to follow the right procedures, right? And then thirdly, it's got to have the ability to calculate very complicated formulas of which instances would justify nil compensation and which instances would justify full market value compensation. Because what it is trying to do is to grapple with a broad concept from the Constitution called justice and equity. Because what the state is trying to do is trying to move from the rigidity of willing seller, willing buyer into a justice-based system. But to give effect to that, it's absolutely necessary to have the right capacity, the right skills, and the right technical capabilities. I am personally very skeptical that we have the infrastructure and the machinery to implement a law of this complication and magnitude as matters stand in South Africa. State capacity has largely been decimated by the years of state capture. So that needs to be reconstructed in order to implement a project like this. And what that means, therefore, is that when politicians go on about this bill being the start of transformation in land relations in this country, they are overreaching and exaggerating and perhaps a bit misleading.
Well, I mean, you also right, or you're the view that we need to be rethinking the whole meaning of land at large. And I know this chat that we've had is going to serve as a conversation starter for many more to come. So thank you very much for joining us at this hour and for weighing in. We'll leave it there for now. Adv Tembeka Ngcukaitobi, lawyer of the best-selling books, of course, Land Matters and Land is Ours, weighing in on following, of course, the signing in of the Expropriation Bill by President Ramaphosa.